Go.
Welcome to the Livermore Indivisible meeting, and thank you for taking time out of your weekend to spend with us. My name is Karen Jefferson, and today's meeting is titled The Equal Rights Amendment, 100 Years and Counting. As Kyoko put it in a recent email, this meeting is a reminder of what women in the United States still do not have: equal rights. This year marks the 100-year anniversary of when the ERA was first written by Alice Paul. After being ratified by 38 states, unfortunately, it is still not part of the Constitution. We have two extraordinary speakers today, Dr. Chi-hye Suk and Andrea Miller, who will tell us about the history of the Equal Rights Amendment and the women who have advocated and championed it and continue to do so, why the ERA is important to our democracy, and how we can make the ERA the 28th Amendment of the Constitution. If you have any questions for either of our speakers during the meeting, please submit them using the Q&A button. Our first speaker is the inspirational Dr. Chi-hye Suk, who is a professor of law at Fordham University and a leading scholar of constitutional gender equality in the United States and around the world. She is the author of two books, We the Women, The Unstoppable Mothers of the Equal Rights Amendment, and After Misogyny, How the Law Fails Women and What to Do About It. She is a frequent commentator in media, such as the New York Times, Washington Post, CBS, and has a June article in the Atlantic magazine titled, Don't Forget About the Other Half of Europe's Abortion Compromise. If you enjoy books that celebrate intelligent, competent, talented, and persistent women, which who wouldn't, then I highly recommend Julie's book, We the Women, and which chronicles women who championed the ERA and legislation advancing women's rights and education. I'd like to read an excerpt, a very short excerpt from the book. The Equal Rights Amendment was instigated by women, written by women, and justified by women after they got the right to vote. It is the only amendment that has been ratified by 38 states about which this can be said. Every other amendment in the Constitution was made by men. It's about time we have female authors of the supreme law of the land. I really want everyone to welcome the wonderful Chi-hye Suk.
Well, thank you so much, Karen, and thanks so much to Livermore Indivisible for inviting me to talk to you this Sunday afternoon in the summer. I prepared some slides, which I'm going to put up on the screen so that we could really talk about, and you can see some of the women who have been making the ERA for at least 100 years, arguably longer than that, and I'll get into that. So if you'll bear with me for 1 second, I'm going to do the share screen. Okay, so if we could, so why don't we just start by talking about what the Equal Rights Amendment is? If you can move to the next slide, Karen.
Mm-hmm.
So that is the text of the Equal Rights Amendment that was adopted in 1972 by both houses of Congress. Section 1 says equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Section 2 says Congress shall have the power to enforce by appropriate legislation the provisions of this article. And then Section 3 says that the amendment will take effect 2 years after the date of ratification. And I want to give a little bit of background because even though it's officially adopted by Congress in 1972, and that's what sets off the ratification process, it is an amendment that's actually first introduced in Congress in 1923. And just this weekend, I was in Seneca Falls to celebrate what we call the ERA Centennial, because on July 21st, 1923, exactly 100 years ago, Alice Paul visited Seneca Falls in order to commemorate the 75th anniversary of the Women's Rights Convention in 1848, where Elizabeth Cady Stanton and Lucretia Mott authored the Declaration of Sentiments. In 1848, the Declaration of Sentiments was a document that women's rights activists wrote, modeled on the Declaration of Independence. And in much the same way that the language of the Declaration of Independence that we so revere for establishing the principles of our democracy, including our commitments to freedom and equality of all persons, in much the same way that the Declaration of Independence did that in 1776, Lucretia Mott and Elizabeth Cady Stanton and many of the women who attended the convention, along with some male participants in solidarity, including Frederick Douglass, they produced a document that criticized the tyranny of men over women and recommitted to the principles of democracy, including freedom, equality, not only for all men, but also for women. That was 1848. And in 1923, 100 years ago this weekend, Alice Paul commemorated the 75th anniversary of that document by visiting Seneca Falls with members of the National Woman's Party. And at Seneca Falls, she revealed a new constitutional amendment that would be proposed. So Karen, if you could show the next slide, that would be great. I have a picture of Alice Paul there. That's Alice Paul in August 1920. So I'm backtracking a little bit by 3 years. In August 1920, the 19th Amendment was ratified. The 19th Amendment is the amendment that says that the right to vote cannot be denied or abridged by the United States or by any state on account of sex. And when the final state, Tennessee, ratified at the time, because we had fewer states, you only needed 36 ratifications to make a constitutional amendment. She unfurled the flag of the National Women's Party, and you could see that on that flag, there was a star for every state that ratified the 19th Amendment. And what's really remarkable about the ratification of the 19th Amendment that simply mentioned that the right to vote couldn't be denied or abridged on account of sex. If we could flip over to the next slide. Karen? We had that amendment. Crystal Eastman, who is the co-author of the Equal Rights Amendment. Crystal Eastman was a graduate of NYU Law School, one of the first women to graduate from law school at all in the early 1900s, and a very brilliant feminist lawyer who also did a lot of work as a labor lawyer at the time, representing workers or working on workers' compensation policy. So Crystal Eastman, who is the co-author of the Equal Rights Amendment, wrote, as soon as the 19th Amendment was ratified, now at last we can begin. That is, despite that image that you see of Alice Paul having a victory lap in 1920, both Alice Paul and Crystal Eastman knew that it wasn't just the end of a long fight, but the beginning of a new one. And the new amendment that they wanted was the Equal Rights Amendment. And one of the things that Crystal Eastman said, as she talked about all of the new beginnings they would see because women have the right to vote, in a lecture she gave called Now at Last We Can Begin, she said, if the feminist program goes to pieces on the arrival of the first baby, it is false and useless. The immediate feminist program must include voluntary motherhood. And I point this out because the author of the Equal Rights Amendment, which doesn't mention motherhood or the right to control your own destiny, whether you have babies or not, the text, of course, doesn't mention that. But the people who wrote the Equal Rights Amendment from the beginning in 1923 understood that the disadvantages that women faced because they were mothers and because of their reproductive role was something that the law committed to equality would have to address eventually. And so that idea was part of the Equal Rights Amendment story from the beginning. So if we could now move to the next slide. And I just want to show you, it was actually worded somewhat differently. It was worded somewhat differently, the Equal Rights Amendment, when Alice Paul and Crystal Eastman drafted it in 1923, 100 years ago. It actually said men and women shall have equal rights throughout the United States and every place subject to its jurisdiction, and Congress shall have the power to enforce this article by appropriate legislation. I point out that different text because one way in which it changed from the 1920s through the 1940s and then to the version that was adopted in 1972 is that you had this general guarantee: men and women shall have equal rights throughout the United States. It gets written in a slightly narrower way by the time it gets adopted in 1940s, in the 1940s, when it's first, in 1950 when the Senate first votes on it, and then by the time we get it in 1972, it says equality of rights shall not be denied or abridged by the United States or by any state. And so that's a slightly different wording, but it's important to see how the original drafters of the Equal Rights Amendment wanted a guarantee of equal rights throughout the United States, not just a guarantee that the state would not abridge it. And that is an important difference that informs what the spirit of this amendment by its original drafters was really supposed to be about. It's also important to note that when Alice Paul introduced the Equal Rights Amendment in 1923, she actually called it the Lucretia Mott Amendment. Lucretia Mott was one of the original organizers of the 1848 Women's Rights Convention that gave rise to the Declaration of Sentiments. And in that declaration, the idea that men and women should have equal rights in all domains, in all aspects of the law. So not just the right to vote, but the right to hold property, the right to become lawyers, the right to have any profession that the law enabled men to have. These were all very important to the original Declaration of Sentiments in 1848. And I want to then now turn our attention a little bit to the idea that the Constitution of the United States does have founding mothers. I've introduced you to Alice Paul and Crystal Eastman and Elizabeth Cady Stanton and Lucretia Mott so far. And this is really important because I just want to say myself, as someone who immigrated to the United States from South Korea when I was a child, I was 4 years old. And I do remember when we immigrated, my parents dreamed of making America their home because they and many people who came to the United States believed that it was the greatest and most successful democracy in the world. And they certainly believed it was a place where their daughters could do everything that boys and men could do and much more. And so when I came to the United States, I was taught to speak English by learning the Pledge of Allegiance at school. So I pledged allegiance to the American flag every day at school. And one of the most important things that we are taught in school is immersion in the genius of our nation's founding fathers. And I have to say that it was not until I became a law professor and a legal scholar decades later that I learned. And in fact, I had to teach myself through reading about the genius of our nation's founding mothers. The genius of our nation's founding mothers was not taught to me in school, and it was not taught to me in law school either, as I trained to become a lawyer and a legal scholar. So I think it is worth highlighting the contributions of the founding mothers of the U.S. Constitution as well. And Susan B. Anthony, she's an important figure because she actually really believed in the U.S. Constitution and the genius of the founding fathers. She believed that the Constitution's guarantee of freedom and equality should include her. And she was incredibly disappointed when the Supreme Court ruled that neither the privileges and immunities of citizenship nor the equal protection of the laws that were in the 14th Amendment after the Civil War, that neither of those provisions included women's right to vote or to hold property or to become lawyers. So it's only then that you see a movement to have the women's right to vote added to the US Constitution. And testifying before Congress in 1880, Susan B. Anthony said she really wanted to believe that the Constitution's promise of freedom provided me and all women the enjoyment of perfect equality of rights everywhere under the shadow of the American flag. But there was a real problem. What was she supposed to do when the Constitution ruled otherwise? And she had an answer to that when she testified in Congress in 1880. Make more Constitution. That's what she said. It's time to make more Constitution. And it's remarkable that she spent the rest of her life fighting for women's constitutional equality, but she was actually dead by the time the Women's Suffrage Amendment was added to the Constitution in 1920. You see Alice Paul in that previous slide, unfurling that flag in 1920. That amendment was called the Susan B. Anthony Amendment, but Susan B. Anthony was no longer with them when the 19th Amendment guaranteeing women's right to vote was passed. We are here again, and we are here again in this very similar moment because the creative genius of 20th century women, and I'm going to talk a little bit more about them in the time that we have together, the creative genius of many 20th century women might have led me and many others to believe that the Constitution, the 14th Amendment, provided me and people of all genders the full enjoyment of equal rights. But last year, the Supreme Court gutted that vision and that hope. In Dobbs versus Jackson Women's Health, 6 justices concluded that our Constitution basically allows the government to control women's reproductive lives, even at the great sacrifice of women's ability to live as equals in 21st century America, which gets us back to what Crystal Eastman was saying as she drafted the Equal Rights Amendment in 1923 about the importance of centering voluntary motherhood, not forced motherhood, but voluntary motherhood as key to a vision of equal rights for women in society. I want to say a little bit now about why the Equal Rights Amendment did not have much traction for several decades before it was adopted finally in 1972. If we can move to the next slide. So one of the difficulties was that the Supreme Court had been deciding a lot of cases in the 1920s that actually that were seen by social reformers, including Florence Kelley, who was an advocate for women workers, particularly in factories, immigrant women workers. The Supreme Court had been striking down laws that social reformers had fought for to protect women workers in factories and in dangerous workplaces. They had been striking down those laws, but initially, for some time, Florence Kelley had defended that you could have special laws for women that would be special protections because of women's capacity to become mothers, because of their reproductive biology. And the Supreme Court actually struck them down in part because they said, well, now that we have the 19th Amendment, women are equal, so we shouldn't have special laws that protect women workers. And so there were some feminists, including Florence Kelley, who opposed the Equal Rights Amendment in the early days in the 1920s. And so when she testified in ERA hearings in Congress in the 1920s, she said, equal rights for whom? Everyone has talked about equality, but no one seems to have dwelt much on the people concerned. So she opposed the Equal Rights Amendment in the 1920s, even though she really very much identified as an advocate for working women's rights. If we can move to the next slide. Then there was also Dorothy Kenyon, who was a feminist lawyer and argued very important cases for women's rights before the Supreme Court. She too, in the 1920s, in the early days of the ERA, opposed the Equal Rights Amendment. And she opposed the Equal Rights Amendment because as a lawyer, she and Florence Kelley were very educated in the law, had gone to law school, and they were concerned that the Equal Rights Amendment would operate, this is in Dorothy Kenyon's words when she testified against the ERA, like a blind man with a shotgun. No lawyer can confidently state what it would hit. And it's really important to understand why feminists were so concerned, ambivalent, not 100% supportive of what seems like an unobjectionable guarantee in the Constitution of equal rights for women at the time. They were concerned that the 9 guys on the Supreme Court would interpret the Equal Rights Amendment in a manner that would actually be harmful to women and would enlarge their own power. And that was a legitimate concern then, as it remains today, because we have to remember that adding something to the Constitution, especially words as abstract as equality of rights shall not be denied or abridged on account of sex. Those are simple and abstract words. They have to be interpreted and enforced and given meaning by someone. So it's not simply the fact of putting words into the Constitution, but ensuring that power is exercised in a manner that advances the interests of women and people of marginalized genders, rather than simply having words that can be distorted, weaponized, and interpreted in a range of ways that might undermine the interests of those it was designed to protect. If we could now flip to the next slide. One of the important turning points, though, because I'm telling you a story of division where women who united for the suffrage amendment could not agree in the 1920s as to whether an ERA, given the state of the Supreme Court at the time, they couldn't agree whether the ERA was really desirable or would be a step forward for feminists. There's something of a turning point in the 1940s, and that turning point comes in part from leaders like Mary Church Terrell. Mary Church Terrell was a Black woman who had advocated for suffrage. She was one of the founding members of the National Association for Colored Women, and she testified in favor of the ERA in hearings in Congress in 1948. And one of the things she did was to actually center the experience of mothers and motherhood. She said, today, thousands of women are obliged to support themselves and their families entirely or help to do so. Today, women sorely need help to discharge their duties and obligations to their families, which the Equal Rights Amendment could so easily afford. And this is where we start seeing through her testimony and through a lot of her advocacy for both civil rights and women's rights. By centering the experience of Black women, she said, well, Black women have always worked. Black women have raised children and worked. They don't always work because they want to work, but because they have to support themselves and their families. And so this is where we start seeing the idea, and it's an idea that takes hold in the late 40s and 50s, that guaranteeing equal rights doesn't have to mean erasing special protections for mothers, that there are ways in which we could think about equality and equity by centering the experience of some of the most vulnerable women in our society, centering the experience of Black women and formerly enslaved women to understand that equality can work in ways that are different from the merely formal version of equality that the Supreme Court had been enforcing in the 1920s, that led some feminists to be skeptical about how the ERA would actually work. And this is why where we see, if we could move to the next slide, that would be great. So jumping ahead, even though there is growing support for an equal rights amendment throughout the country in the 40s, 50s, and certainly in the 1960s with the civil rights movement and the growing wave of second wave feminism in the 1960s. One of the reasons why the Equal Rights Amendment, despite increasing amounts of support, doesn't even get voted on in Congress in the 1960s. There is a vote in the Senate in favor of the ERA twice in the early 1950s, but it never gets a vote in the House. And there's a simple reason why it doesn't get a vote in the House. It's because Emanuel Seller, that's the man on the right, he is the chair of the House Judiciary Committee and the chair of a the House Judiciary Committee gets to decide whether that bill is going to be reported out and voted on by the rest of the House of Representatives. And so in order for it to get a vote, because once it actually gets out on the floor, it's immensely popular. But in order to get past Emanuel Seller, Martha Griffiths, who is the mother of the Equal Rights Amendment, she was the primary sponsor in the House throughout the 60s and early 70s, what she had to do to get it on the floor and to get a vote for it at all was to organize what's known as a discharge petition. A discharge petition, what it does is it wrests control over a bill or a resolution from the committee that would normally be in charge. And so in order to do that, though, you need to get half of the House, 218 members of the House, to individually sign that discharge petition. So she did it. She just went and confronted people, mostly men in the House of Representatives at the time, and she got that discharge petition so that they could have a debate on the floor and a vote on the floor. And it's quite remarkable what happens, because when they finally get it on the floor in August 1970, there's an overwhelming vote in support of the Equal Rights Amendment. And at the time, it's an overwhelming support in the House for an Equal Rights Amendment that does not even have a ratification deadline in it. And they get a vote of 352 to 15, but unfortunately, it stalls in the Senate. And if we can see a copy of the text again, which is the next slide. So that's the text, and that is the text that was adopted in, it's very, very close to what was adopted in 1970 with no deadline as well. But the reason it doesn't get adopted in the Senate that year is that it doesn't come to a vote. There are a few men, a very small number of men, including Sam Ervin in the Senate, who oppose the ERA, and they prevent it from coming to a vote before elections. So the ERA dies, even though it had overwhelming support in the House with no deadline in 1970. I want to just say a little bit, since I've been talking more about the political strategy around the ERA, a little bit more about the substance of why women like Martha Griffiths and then some of her colleagues in the House, there were a very small number of women in the House, but it is amazing that there were women of various race backgrounds and different across the political spectrum who united in support of the ERA in 1970, 1971, and 1972. So if we look at the next slide, an important figure is Shirley Chisholm, who was the first Black woman elected to Congress. And it's important to see what she said about the ERA when she debated on the floor in 1970. She saw it as the fullest expression of that equality of opportunity which our founding fathers professed. They professed it, but they did not assure it to their daughters as they tried to do for their sons. Again, expressing a very similar idea to Susan B. Anthony. There are these amazing principles in our Constitution, but they've somehow fallen short because they just didn't expand it to include everyone. And then she says it explicitly. There were no Black founding fathers, there were no founding mothers, a great pity on both counts. It's not too late to complete the work they left undone. And so she sees it as an issue of constitutional authorship, that if you don't have founding mothers, you aren't going to be able to expand the principles to include everyone that needs to be included as we approach the end of the 20th century. If we flip to the next slide, Patsy Mink, she is the first Asian American woman elected to Congress. She's elected just very shortly before Shirley Chisholm is from Hawaii. And she was also a graduate of law school, one of the very few women to graduate from her law school class at the University of Chicago. And she did a lot of thinking about what the ERA would actually do in 1970, in the early 1970s. Why was an Equal Rights Amendment necessary in 1970? And by the time you get to 1970, the reasons why the ERA is important are a little bit different from the reasons they were important. The ERA was important to Crystal Eastman and Alice Paul in 1923. In 1923, there were still a lot of laws that prevented women from holding property or getting a credit card, right? There were a lot of laws that actually held women back. By the time you get to the 1970s, some of those laws have already been taken off the books. But Patsy Mink is concerned not just with the laws that explicitly exclude women from rights, but laws that disadvantage women. And so now it's not that you need a constitutional amendment to strike down those laws. What you need a constitutional amendment for is to empower Congress and to just send a clear message to Congress and all the state legislatures to pass new laws that would make equality real for women. And this is a conversation that's very important in the House at the time, where they talk about actual disadvantages women face, not just because the law excludes them, but because there are all kinds of policies that disadvantage women. And she says, we want to make it clear from the legislative record that we are creating, that is being made today, to guide judges in the future so that they know what is intended by the Equal Rights Amendment. If we can go to the next slide, I want to point to some of the Republican women because I mentioned it's so crucial to the ERA's history that it was a bipartisan effort, and women on both sides of the aisle supported the Equal Rights Amendment. And one thing that was important to the Republican women was this valuing of mothers and attention to disadvantages women faced because they were mothers. And they wanted to be really clear that their support for the Equal Rights Amendment was not intended to eradicate the differences between women and men. So Florence Dwyer, who's a Republican from New Jersey, says it would invalidate laws prohibiting women from working in certain occupations and excluding women from certain colleges and universities. And laws which restrict the rights of married women, which carry heavier criminal penalties for women than for men. But importantly, she says it would not take women out of the home. It would not downgrade the roles of mother and housewife. Indeed, it would give new dignity to these important roles by confirming women's equality under the law, by upholding women's right to choose her place in society. The Equal Rights Amendment can only enhance the status of traditional women's occupations. For these would become positions accepted by women as equals, not roles imposed on them as inferiors. And this strand is really important if you think about some of the culture wars that end up derailing the ERA later. It was so important to the ERA's history that it was not intended to denigrate the role of mothers, but rather to make sure that motherhood is chosen rather than imposed. And motherhood does not become a source of disadvantage. Here she's echoing what Crystal Eastman said as she was drafting the Equal Rights Amendment in the early 1920s. If we could shift to the next slide. This is Margaret Heckler. She was a Republican from Massachusetts, also echoing the sentiment. I do not have any desire to become one of the boys. That is, the Equal Rights Amendment would not make women the same as men, but she also emphasized the importance of equality as a basis for supporting mothers in their in the burdens that they sometimes faced because they were primarily responsible for childcare. And she pointed out many countries we consider underdeveloped far surpass America in the quality and availability of childcare available to working mothers, in enlightened attitudes about employment leave for pregnancy, and in guiding women into the professions. This history is really important, and just the through line, if we look at the next slide, we have Bella Abzug, who was a Democrat, but echoing very similar sentiments to the Republican women at the House at the time. She says that there is a female force, yet we don't have a universal childcare system in 1971. And honestly, that was 1971. We still don't in 2023 have a universal childcare system. But she points out the disadvantages that women face because they're mothers, and also that a lot of working class women are working because they have to. And the vision of equality that the ERA is supposed to be about always has to include the women who are working because they have to, and the disadvantages that women face because they are mothers. So now if we flip to the next slide, of course, things get very confused in Congress. The opponents of the ERA, Emanuel Seller in the House and Samuel Ervin in the Senate, they hold the floor. And Ervin had filibustered. He was a segregationist from North Carolina. He had filibustered the Civil Rights Act. And we don't use the word filibuster so often to talk about what happened to the ERA. But if you read the legislative record, as I have, that's basically what goes on with the ERA as well. Sam Ervin just kind of holds the floor and says the ERA is going to destroy motherhood. The ERA is going to denigrate mothers. And that's why we can't have it. And another thing he says is, if we're going to have it, we better have a 7-year deadline on it. And he doesn't prevail. He holds the floor for many, many hours trying to stop the ERA. But one of the things he's very vocal about is that 7-year deadline. And even though he is a very tiny minority of the Senate, it turns out that in our great democracy, a tiny minority of the Senate can exert a tremendous amount of power by being willing to hold the floor and being willing to be a pain. And that's what he does. And that's why, and it's important to understand this, that when Martha Griffiths comes back to Congress in 1971, after the ERA dies in the Senate in 1970, when Martha Griffiths reintroduces the legislation, let's move to the next slide. The preamble of that legislation and the version that gets passed, and the version we're still talking about today, has that 7-year deadline in it. It says the following article is proposed as an amendment to the Constitution of the United States, which shall be valid to all intents and purposes as part of the Constitution when ratified by the legislatures of 3/4 of the several states within 7 years from the date of its submission by the Congress. So I will, just in the interest of time, because I know we got started a little later than we intended. One thing that's important to understand about this language is that it says in the preamble that it shall be valid to all intents and purposes as part of the Constitution when ratified within 7 years, when ratified within 7 years. That seems to express it's definitely in the Constitution if it comes back within 7 years, but it doesn't say what happens if it takes longer than 7 years. I think many of us know the story of what happened, so we could flip through the next quick bunch of slides. We have Polly Murray, who testified and said the ERA was really about equal power as much as it was about equal rights. If we could flip to the next one. Phyllis Schlafly, who took advantage of the 7-year time limit in her Stop ERA campaign to campaign particularly her home state of Illinois, a pivotal place where the ERA did not pass in the 1970s. And she, like Sam Ervin, claimed that the ERA would destroy American motherhood. And if we could flip to the next couple. These are quotes that you'll see, but what I want to point out about Liz Holtzman and Barbara Jordan in the history of the ERA is that they worked hard to extend the deadline on the ERA. That language that I read you, when ratified within 7 years, because it's in the preamble, a lot of brilliant women, including Barbara Jordan, who is the first Black woman to be elected from the South. She's on the next slide, Karen. They worked really hard, Liz Holtzman and Barbara Jordan, in around 1977 to extend the deadline. because they believe that if it was in the preamble, Congress had the power to change that deadline. Furthermore, this is the argument that's being made today, that if Congress had the power to change the deadline once in the 1970s, then they have the power to change it again by extending it by however many more years, or just eliminating the deadline altogether, or forgiving it. And that's also consistent with the language of that deadline. If we could just scroll back, I'm sorry, Karen, to just before that one. Oh no, before. Here we go. That one. The language in the preamble, which says that the ERA is valid as to all intents and purposes when ratified by the legislatures of 3/4 of the several states within 7 years. So it's valid when ratified, but we don't know what happens if it's ratified within more than 7 years. All we're sure of is that it's definitely in if it's within 7 years. That doesn't mean it's definitely out if it doesn't get done within 7 years. And that takes us to where we are today with the ERA. I think Karen mentioned in her introductory remarks that what happens by 1977 is that the ERA is ratified by 35 states, and you need 38 to get to 3/4 of the states. So Karen, if we could scroll ahead a little bit. Article 5 of the US Constitution tells you that you need 2/3 of both houses of Congress and 3/4 of the state legislatures. There are other ways of amending the Constitution also mentioned in Article 5, which have generally not been used. The primary way in which we've amended the US Constitution is by operating under the provisions that say 2/3 of both houses of Congress and 3/4 of the states. So we got 35 ratifications, which is not 3/4 of the states. It's 3 states short of 3/4 by 1977. Congress, with the leadership of Liz Holtzman and women like Barbara Jordan, they extended the deadline once. They extended it by about 3 years, but no further states ratified by 1982, which was the end of the extended deadline. But then 3 states, including Phyllis Schlafly's home state of Illinois, came through in more recent years. So 2017, we get Nevada, 2018, Illinois, and 2020, Virginia. So there are 3 additional states that ratify, and now Congress has tried to act to extend that deadline again, or rather to eradicate it altogether. So if we move on to the next slide, Karen. So SJ Res 4, this was again, so we're seeing like a history and tradition around the ERA here, filibustered. So there was a vote in the Senate, and it was 51-47, meaning the majority supported it, removing the deadline for the ratification of the Equal Rights Amendment. So if you see that resolution, it basically says, since it's been ratified, or having been ratified by the legislatures of 3/4 of the several states, it's resolved that it's valid to all intents and purposes, notwithstanding the time limits expressed in that earlier resolution. The House had passed essentially the same resolution in the previous legislative chamber, but hasn't voted on it now. Ayanna Pressley is leading a discharge petition in the House right now, just like Martha Griffiths, to try to get it to a vote in the House right now. It isn't clear that you would get a majority of the House in support of that resolution if it made it to the floor. But it is significant that even with majority support in the Senate, it can't pass because under the filibuster rules, you need 60 votes to close debate and then to bring the motion to a vote. And now we also have, if we could move to the next slide, there's a new resolution that was recently introduced just this month by Senator Gillibrand and Representative Bush. And this one just recognizes the ERA as ratified because it has met the requirements of Article 5 and tries to call upon the Archivist of the United States to publish the ERA. I'm going to end my remarks, and I'm happy to talk more about it in the question and answer by just pointing to, if we could get to the final, I think, last slide, one more. So I just want to say a few words because I think there are different perspectives provided by lawyers and activists with regard to this. Illinois versus Ferriero was the lawsuit in which the 3 states that ratified, Nevada, Illinois, and Virginia, sued the Archivist of the United States, saying that the Archivist should just publish the ERA and add it to the Constitution because 3/4 of the states have ratified it. Of course, the idea behind that lawsuit is that the 7-year deadline is not valid, but the lawsuit was actually dismissed, and it was dismissed by a judge that was appointed by Obama. And then on the DC circuit, the 3-judge panel, 2 of whom are Democratic appointees, not Trump appointees, on the court, they also held that the states lacked standing and concluded that the states have not clearly and indisputably shown that the Archivist had a duty to certify and publish the ERA, or that Congress lacked the authority to place a time limit in proposing the proposing clause of the ERA. What's really important about all the lawsuits is that they tend to focus on the Archivist and the Archivist, whether the Archivist publishes the ERA or not. And this is the sense of many people who are in the legal space, including many who are totally supportive of the ERA, including myself and all of the judges who have looked at this, that it does not matter whether the Archivist publishes the amendment or not, because if it's valid because Congress acts, or if it's valid because the deadline is unconstitutional, then whether the Archivist publishes or not, it is part of the Constitution. If it's not valid and the Archivist publishes it, then it's not part of the Constitution. So the simple fact of adding it to the document has no bearing on whether it's law or not law, although it might make a difference to whether or not people looking at the Constitution are willing to support it politically. So why don't I just end there? I'm happy to talk more about the history or about just the legal limbo that the ERA is in right now in light of everything that came before.
Would it be okay if I would stop sharing at this point?
Yes, absolutely.
Okay. I have a question for you, Julie. One of the things, why is it so important to have the Equal Rights Amendment from your perspective in the Constitution?
So it's really important because the United States has one of the oldest constitutions in the world, and most other countries that we consider to be our peers as democracies have modernized their constitutions. And today, in this day and age, if you were writing a constitution, you would not write a constitution without a provision on equal rights between women and men, or without a commitment to sex equality, without an explicit recognition that women are equal citizens. You just would not. It's like freedom of speech, the right to vote. These are the basics, like fundamentals of democracy. So it's highly abnormal in the world of running a decent democracy to have a constitution without a commitment to sex equality. I think that's the most important answer to that question. I think one of the things that we've done, and we've done this not only with gender equality, but with many things. Just imagine if you lived in a house that was built in the 18th century, but you weren't allowed to bring modern plumbing, or you weren't able to update it, what would you do? And we've created a lot of makeshifts, and the makeshift that we've created in the United States is we depend on the Supreme Court. We don't change the Constitution by amending it, but we ask the Supreme Court to interpret it in a way that's favorable. And we in the United States, and I think Ruth Bader Ginsburg was perhaps the most important figure, as well as Pauli Murray. Ruth Bader Ginsburg was really creative and created many arguments that were successful for some time that read sex equality, women's equality into the 14th Amendment of the US Constitution. And it's the 14th Amendment that became the basis for Roe versus Wade. We convinced 9 male justices in Roe versus Wade to even find a woman's right to choose an abortion in the US Constitution. And so that has been our primary method of modernization. But look what the Supreme Court is doing now. I think it's really clear that we cannot rely on the Supreme Court at all times to modernize the Constitution. It's a highly unusual and dysfunctional way of modernizing a Constitution. And that's why the ability to amend the Constitution, to modernize it, and to include everyone who really deserves to be included in explicitly in its protections, that has to be a basic building block of a legitimate political and legal order. And if we can't do it, it really speaks very poorly of the democracy that we live in.
We have a question that asks, could you please discuss the legal differences, considerations between using the word sex versus gender or something else?
So I think that the word gender is probably a better word to describe what we are trying to get at with the commitment, with the principles behind the ERA today. I think the reason it says sex is that when it was initially drafted in 1923, gender was really just not a word that was familiar to people. And even in the 1970s, people really, I think our ideas about the relationship of biological sex to the social construction of gender have evolved significantly from the 1970s. So I do think that if we were drafting from scratch today, we might use the word gender rather than sex. But if the movement to enshrine the 1970s ERA continues, you can't change the text when you ratify it. You'd have to start over if you wanted it to say gender. But I do think that in the 21st century, gender probably speaks more clearly to what we mean when we say the word sex, because we're not just talking about biological sex differences. We're also talking about sex as a social construction, sex as stereotypes and social roles that have been imposed on people who have been biologically identified as female. And for that reason, this is an interesting puzzle as well, that I think part of the reason the movement, the ERA movement, has really embraced the 1970s ERA is that it's a sad and tragic fact about the US Constitution that if we tried to start over and create an Article 5 amendment today, we would get nowhere. Like, we can't imagine 2/3 of Congress agreeing to anything at all, let alone agreeing to an amendment on gender equality in 2023. And I think that's why there is an effort to try to take what was written in 1972 and give it new meaning. But I think the new meaning that we're trying to give to the word sex today certainly includes the word gender, and the word gender could include both sexual orientation and gender identity, as well as pregnancy. But I think the reason there's a commitment to using the word sex is that it's what's already there in something that has a long and transgenerational history and trajectory that we're picking up.
We have another question that asks, who would have standing now to sue to determine that the amendment is valid with the current ratification?
So typically, standing means that because Article 3 of the US Constitution says that you need a case or a controversy, somebody has to suffer an injury in fact. I think the reason the states invented the legal strategy of suing the archivist is that if we go back, well, I'm not going to have you share my slides again, Karen, but I just want to remind folks that the text of the ERA that was adopted in 1972 and has been ratified by all these states, it says this amendment shall take effect 2 years after the date of ratification. That's in section 3 of the text. And because by its own terms, it said it doesn't take effect until 2 years after the date of ratification, if you wanted to sue like the day after ratification, because the amendment doesn't take effect for another 2 years, you would, no one is technically injured by any confusion about the amendment on the day after ratification. But the states wanted to seek that certainty immediately, so they claimed that there was an injury by the archivist not publishing. And it wasn't a great theory of standing, and it wasn't surprising that the courts rejected it. So I think now you might say, if you actually believe that it was validly ratified on January 27, 2020, when Virginia issued its ratification, if you believe that, then 2 years after the date of ratification, would have already been January 27th, 2022. So if you think that the amendment is in effect, then you can claim if a state is discriminating on the basis of sex, if the state is doing something, has a policy that denies your equal rights on the basis of sex or on account of sex, then you can allege the injury. Like if you have lost money or been excluded from an opportunity or excluded from a job, then that to me would be a much clearer theory of injury rather than a state claiming they're somehow injured because the archivist hasn't published the amendment in the official copy of the U.S. Constitution.
I'll ask you one last question that is always at the top of my mind. Do you have any advice or recommendations to us as a group of how we can make this ERA a possibility? What advocacy suggestions do you have that we could follow and pursue?
So I think one of the biggest challenges for the Equal Rights Amendment is that a lot of people don't know about it. And there's great confusion, and it's a real problem. There is not a lot of agreement amongst lawyers or amongst politicians and amongst the people as to what it would even take to totally legitimize it. Those who oppose it, and I wouldn't say it's just those who oppose it, even people who are in favor of it are a little bit skeptical of its checkered procedural history. And the checkered procedural history not only includes the late ratifications, the fact that the last 3 came in 30, 40 years after the deadline. So that's one problem. But another problem is that there were 5 states that voted to rescind their ratifications in the 1970s within the 7-year time limit. So for those reasons, even people who are totally supportive of the Equal Rights Amendment as an amendment, including the late Justice Ruth Bader Ginsburg, are a little bit skeptical about legitimizing an amendment that has had this checkered procedural history. So I think that the most important thing for, if you're interested in a long-term way in legitimizing the amendment, it's really trying to think about those who are skeptical, not just skeptical because they hate women's rights, skeptical because they really believe in the process and they want to see a fair process by which the Constitution gets amended. On the one hand, if you look at Article 5, it doesn't look like a very fair process. It seems, compared to most countries in the world, the notion that you need to get 2/3 of both houses of Congress and 3/4 of the states, that seems totally impossible. But if you accept that as the law and the process that you have to follow to amend the Constitution, and you want to work within that to create a legitimate constitutional amendment, I would say that the most likely path to legitimize the ERA is to get Congress, both houses of Congress, to vote to recognize the ERA as validly ratified and to say notwithstanding the deadline or the rescissions. And if both houses of Congress took a vote to recognize the ERA as validly ratified, notwithstanding these procedural imperfections, I think that would be probably the most promising path forward. Although that too seems daunting because it seems like because it was filibustered in the Senate, even if you had a situation where you got both houses of Congress to vote on recognizing the ERA as ratified, even if you got a majority in the Senate, you would need 60 votes to defeat the cloture motion or to bring it to a vote in the first place. And I think because the ERA has been largely partisan, we have some exceptions like Lisa Murkowski and Susan Collins, who are Republican women who have supported the ERA in the Senate. Those exceptions are rare. It's become extremely partisan. And while it's that partisan, it doesn't seem, it seems like it's going to be really difficult to get 60 votes in the Senate to support the recognition of the ERA as validly ratified. So I do think that those who are really interested in having the ERA added to the Constitution should really focus on filibuster reform, because I don't see it happening, even if the Democrats win both houses of Congress. I don't see a lot of meaningful legislation, including this one, passing without filibuster reform.
Thank you very much. Would you mind if I would ask one more question that came in?
Oh, not at all.
And it has to do with the, let me see if I can get it up again. What were the primary reasons for the states who rescinded their ratification of the ERA?
So the states that rescinded, they took back their ratifications because they claimed that they didn't realize that it was complicated. Meaning, so one thing that you see when the ERA is adopted by both houses of Congress in March 1972, a lot of states just ratified it really quickly without even having a debate about it. It was a no-brainer. There was a funny thing. Hawaii actually ratified it before the congressional vote was totally complete. So they ratified it before it was even time. So for many of the states that ratified it, it was just kind of a no-brainer. It was immensely popular amongst both Democrats and Republicans. So a lot of the initial like the first 30 ratifications, many of those states, if you look up the record, they didn't even have a debate about it, and they voted yes. But then once Phyllis Schlafly's movement against the ERA really took off, and these were the networks of conservative women operating in a lot of states, primarily in the South, once they started their Stop ERA movement, they had contacts in some of the states that had already ratified, and they started lobbying some of their state legislatures, like, hold on, that maybe we don't want this amendment. And so they convinced some of the state legislators to re-vote or to take a vote to rescind their ratifications. And so it did come down to some of these issues about, well, basically Phyllis Schlafly and Sam Ervin in the Senate in the early 1970s, they all claimed that if you had the Equal Rights Amendment, you would have to treat men and women the same all the time. They claimed that you couldn't have separate women's and men's bathrooms. They claimed that you would have to draft women into the military. They claimed that and that's an issue that I think has evolved. I think today we have women in the military, we have women in combat. It's not much of an issue anymore. But certainly I think the very idea that you would always have to treat men and women the same, that was the fear-mongering campaign that was somewhat successful. And I think that's what was behind the 5 rescissions.
Thank you very much. This has just been so wonderful. Thank you for your time. And if we were in a room, I would ask for a round of applause, but you wouldn't hear it anyway. So thank you so much for a wonderful talk and telling us about the Equal Rights Amendment. You are amazing.
Thank you so much. I apologize for the hiccup with the slides in the beginning, but I did want everyone to see that it's not just words on a page, but a lot of women who were there fighting for it.
Thank you so much. It was a truly wonderful talk. Thank you so much.
Thank you.
And our Kyoko, our next speaker is going to be Andrea Miller. And she is as amazing as Professor Suk. Andrea Miller is the founding member of the Center for Common Ground, which is a major provider of scripts and addresses for Livermore Indivisible's postcarding effort. She is also the executive director of People Demanding Action, founding president of the National Women's Political Caucus of Virginia, and a member of the Democracy and Governance Working Group of the Virginia Green New Deal. Her expertise is in voting rights, climate, and the Equal Rights Amendment, and has successfully advocated for legislation on both the federal and state level. We welcome Andrea.
Well, thank you all very, very much. It is a delight to be here. I literally just got back from the 7th annual Women's Summit. Now, I don't know if everybody is looking in the chat, but I lobbied on Capitol Hill from 2009 to 2019. And I was the lead lobbyist on removing the ratification deadline on the Equal Rights Amendment. When a group approached me in 2009 about wanting to remove the ratification deadline, I had started working on the Equal Rights Amendment when I was 11 years old. I am now basically 70 years old. And I looked at the Equal Rights Amendment. It was a big part of activism for my mother, who told me, well, women, when we look at women and men, women are really superior. If men had to have children, everybody would be an only child. She said, but as women, we will settle for equality. Those are my mother's words, not mine. But I still remember them to this day. And I can remember traveling with her. I am from Illinois. So I've been involved with the Equal Rights Amendment in Illinois in the 1960s and the 1970s. I mentored a young man in Nevada. So in some ways, I was responsible for the Equal Rights Amendment in Nevada. And I have lived in Virginia since 2006. And I was very, very honored to make the closing argument in the Virginia House of Delegates for why they were going to ratify the Equal Rights Amendment. And I suppose if I go back to 2009, I am one of the leading people responsible for saying, when we look at the Equal Rights Amendment, it's very simple math. 3 is less than 38. Meaning if we picked up the version of the Equal Rights Amendment that already had 35 ratified states, there were 15 states that were unratified, and we really only needed 3 more. That was a lot smaller number than trying to get 38 states to ratify. Now, even in 2009, and we are not nearly as polarized then as we are now, Texas would not have ratified. Wyoming would not have ratified. Idaho would not have ratified. So a number of the states that were ratified would not ratify again on a new equal rights amendment. So my thought was 3 is less than 38. We are going to need to create a huge movement so that people understand ERA is neither earned run average, nor is it a real estate company. We are really talking about the rights of more than 50% of the population of the United States. So it was a very interesting, fun, and rewarding time. I'm going to share my screen because I would love for you to look at some of the activist history that and some of the things we used to make people see and understand the Equal Rights Amendment. Back in those days, I was with Progressive Democrats of America, and we actually created an issue team called the ERA 3-state strategy. And this is one of our old flyers. And you can see Senator Elizabeth Warren was finally on the Equal Rights Amendment, removing the ratification deadline. And we say very clearly here, our mission is we are dedicated to ratifying the Equal Rights Amendment in the timeliest manner possible to finish what Dr. Alice Paul started 90 years ago. Our strategy is twofold: removing the ERA ratification deadline on the national level by educating Congress to support and then it was Joint Resolution 15, SJ Res 15 and HJ Res 43, while simultaneously organizing in targeted unratified states to gain the 3 additional states required to make the Equal Rights Amendment the 28th Amendment of the United States Constitution. This flyer goes back to 2010. So just kind of a fun little history there. And it's really, really kind of fun looking back at this and going, I'm remembering now a lot of the arguments we used about what we were going to do and why we were doing it the way we were doing it. And we had a lot of meetings. Every physical meeting we went to, everything we did on Capitol Hill, we had these 2-page front and back flyers. So help move the Equal Rights Amendment forward. And we would just bring this to everything that we went to see. In Virginia, we had an organization, Women Matter, Use Your Power, and we used the graphics that showed all the people demanding the Equal Rights Amendment. And we also, again, this is now the it's the 21st century. So we went, not that one, we went digital. We had petitions where we actually attempted to try to help people understand that when we look at the pay disparity on the Equal Rights Amendment, that not only is it a disparity of sex, it is also a disparity on race. And the idea was we framed this as an economic equality issue, the #1 issue for women, economic equality. 40% of wage disparity is due directly to sex discrimination. Compared to every dollar a man makes, women make. Asian women were 87 cents to a man's dollar. White women were 78 cents. African American women were 64 cents. Native American women were 60 cents. And Hispanic women were bringing up the rear, and they were at 53 cents. So again, this is 2010, 2011. Things have not progressed that much farther today. Let's give every woman, every racial group, an increase of 3 cents. That's all we've done in all this time. So it has been a very, very long fight and a very, very long road to hoe. Now, what I am loving about what I am seeing is I love the resolutions that basically say, all right, we did what you asked us to do. We got the 38 states. We're there. Let's officially say the damn thing is ratified. Now, right now, are we going to get 60 votes in anything in this current Congress, in the Senate? Highly doubtful. It is incredibly doubtful we could get 60 senators to agree. Up is up, the sky is up, and the earth is down. That is just how ridiculously polarized we are. We are seeing, if you follow other issues like the National Defense Authorization Act, the insanity that the House is talking about putting in a must-pass bill is absolutely mind-boggling. So we are at a very peculiar point in history where it is nonsense, the tail that is totally wagging the dog. We want to do crazy, so we are going to prevent people from doing necessary business, or at least, in my opinion, that is what I am seeing on Capitol Hill. So we just reintroduced the Freedom to Vote Act. Is that going anywhere in this Congress? Absolutely not. It doesn't matter what the issue is. It is probably not really going much of anywhere in the 118th Congress. Now, again, I always love to say that is why elections matter. And that is one of the reasons why I stopped lobbying on Capitol Hill and went back to an old love, working on elections and turning out voters. So when we are looking at what we're going to do in Virginia, yes, there is this huge revival, or it's not huge yet. We're working to make it bigger, to make sure people understand where the Equal Rights Amendment currently is. For a long time, oh, we have to get Virginia to ratify the Equal Rights Amendment, and then Virginia ratified it. And people really haven't heard a lot about where we are since Virginia ratified, because it's very difficult to describe where we are. Well, Virginia ratified, and we sued the archivist, the attorney generals of the last 3 states, Nevada, Illinois, and Virginia. And why did the archivist not publish the Equal Rights Amendment when he had originally told us that he would? Because Mr. Trump overstepped the boundaries of his office and told the archivist not to publish the Equal Rights Amendment as the 28th Amendment. So there's this interesting conundrum. We don't push President Biden to overstep his boundaries and tell the archivist to publish because that was wrong. So 2 wrongs in this instance could, in theory, accomplish a goal, but it would then further confuse, wait a minute, who really is supposed to follow the rules that have been set for what branch of government, what functional arm of government is allowed to do what. Now, what I would love to do is kind of stop here, see if there are any questions before I go on, because I was really going to say something slightly different, and this just seemed so apropos in terms of what Dr. Suk said, because some of this is my fault.
I do not see any questions right now. Andrea, will you be addressing some of the amazing Black women that have been
Yes.
important, especially the current effort has just been amazing.
Yes, yes. And there is a very young Black, well, he's not that young anymore, but there's a young Black man that is sort of hidden from history. So when we look at the Equal Rights Amendment, and I've got them all written down so I don't forget anybody, we have a lot of names like Annie Williams, Phyllis Wheatley, Mary McLeod Bethune, who were very, very involved with Black women's movement and were interested in working with Alice Paul right after the 19th Amendment was passed on voting rights for women, and being able so that Black women would be able to vote. And then this new notion of equal rights for women. So in those days, you had the National Association of Colored Women, and then you had Alice Paul's new party, the National Women's Party. So again, when you're looking in the 1920s, the United States is a very segregated place. And while the women periodically made overtures to each other and tried to get together, it never actually really worked out. And we don't really see the Black women and white women working on the Equal Rights Amendment together until Shirley Chisholm shows up in Congress. So at that point, and by now it's the 1970s, it's 50 some odd, it's nearly 50 years later, we're now seeing people that are not white, not necessarily with a middle class background, saying this is really an important thing. We want to see this put together. And probably the biggest push we really started seeing was with women in the South. They went and got the men in the NAACP and said, you know, we've really got to look at building out rights for everybody. So we all know we have that beautiful history of this is what happened when it went to Congress and when it finally came out. I'm now going to jump all the way to 2017 to the point where the states start ratifying again. There was a young man who joined Progressive Democrats of America in 2015, and his name was Johnny Johnson. And Johnny joined me one evening for an Equal Rights Amendment 3 state call. And after the call, this is before we had Zoom, this is when we were doing conference calls. After the call, he called me up and he said, he said, I'm the youngest of 8 children. He said, this would have made a world of difference to my family if this had been available and my mother had gotten paid equal for the work that she did. And this became very, very important to Johnny. It was right up there with voting rights work, and occasionally it even superseded his voting rights work. Johnny had been a formerly convicted felon. So that meant his work opportunities were somewhat limited. So in Nevada, he spent a tremendous amount of time working on political campaigns. And he was really, 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 really good at it. And so after the elections in Nevada, Senator Pat Spearman called Johnny into her office and said, we have appreciated all the work you have done on our political campaigns as a volunteer for the past 3 years. And I know you thought we weren't listening every time you tried to talk to us about how important it was for Nevada to ratify the Equal Rights Amendment, but we were listening. And next week, Nevada will ratify. Senator Pat Spearman just happens to be from Petersburg, Virginia. So when Virginia, and we had really been amping up ratification since 2010, when Nevada ratified, Virginia was like, well, we'll be next. So Nevada is state 36, Virginia will surely be state 37. So we started looking for, we decided we wanted women co-sponsors or women lead sponsors on the Equal Rights Amendment. So we ended up going to a young woman in Virginia. I saw her yesterday and today, Jennifer Carroll Foy, who carried our bill in the House, and Senator Jennifer McClellan, who earlier this year was elected to Congress. And so we were not successful in 2018. We did not control the House. We had been passing ratification of the Equal Rights Amendment in the Senate for 5 years straight. So Virginia has an election every year. The election of 2019 produced the results that we wanted, and we had the Virginia House. So when we reintroduced in the 2020 legislature, that was when Virginia ratified. Now, the moment that Virginia ratified, then the US House passed the remove the ratification deadline from the Equal Rights Amendment. We didn't have 60 votes in the Senate, so we didn't go anywhere in the Senate. In March of this year, the House formed the caucus or the Equal Rights Amendment caucus. And I want to make sure I do not leave anybody out. So with Congress in 2023, the 118th Congress, they wanted to make certain that the Equal Rights Amendment had its own caucus. It had its own interest group. In other words, this is something that we take seriously. So the co-chairs of the caucus are Congresswoman Ayanna Pressley and Congresswoman Cori Bush. So Massachusetts and Missouri. These are two African American women who are the co-chairs, if you were, of the, as they put it, first ever Congressional Equal Rights Amendment Caucus. Then we have Becca Balint from Vermont, Nanette Badagan, Judy Chu, Madeline Dean. These are all women of color. Lois Frankel, Stephen Horsford, whom I met back in 2017 in Nevada, Sydney Cobbler Dove from California, and then Barbara Lee, who had from the very beginning always been a co-sponsor on both strategies, remove the deadline and start over. Summer Lee of Pennsylvania, Jen McClellan, who literally had gone to Congress the week before and had been sworn in, Mark Pocan of Wisconsin, Delia Ramirez, our own Jamie Raskin of Maryland, our constitutional scholar, and my own Congresswoman, Abigail Spanberger. Now, I showed you a slide earlier where I said, this is the handout that a group called Women Matter, Use Your Power had used in Virginia. And the founders of that group, every single day that the Virginia legislature was in session from 2019 to 2020, they were at the General Assembly each and every day, whipping up support for Virginia's ratification. So today, last night, I got to speak as the president of the National Women's Political Caucus of Virginia. And we are very, very excited about supporting the Equal Rights Amendment Caucus, and then also supporting the strategy for the new resolutions. So I'm going to drop a link in the chat. This is the press release on the founding of the caucus. All right. Yes. Yes, there is the ERA coalition. They're a very interesting group. We are the grassroots group that works sort of behind the scenes that no one ever sees. They are the group that raises money. So, are there questions on that? I mean, this is a very quiet group.
I did not
Yes.
see, oh, I do not see any questions in the question and answers. It does seem like it's a very, very quiet group. So
Yes, yes. I'm not used to people being this quiet. Normally, we've got people all over the place. We're also in a webinar room. So I think that just sort of makes people feel like they're supposed to like be good and be quiet. They're in a webinar room.
do you have any, could you say a few words about Paula Murray? She has been somehow overlooked in many women are overlooked in history, let's face it. But somehow she was instrumental, certainly in the 60s, 70s, as far as her interpretation of law. And I was just wondering if
you picked someone that I have not even followed.
Okay.
Yes. Yes, I have not followed her. I did not go back and look at a lot of the legal interpretations. What we were looking at was who were the people who were the activists. And Shirley Chisholm, Bella Abzug, Fannie Lou Hamer, they all came together and they formed the National Women's Political Caucus, which in my mind was, let's bring the African-American women working on equality and the white women working on equality. Let's come together and finally build that organization. Yes, I would love to have the chat so that everybody could see the chat, because the links that we dropped in, I'm chatting only to hosts and panelists, so I'm talking only to you guys. Yeah, I mean, you may be sharing them out to others. Ooh, can I stick them in the, nope, there's no open questions.
Right. You could talk about some strategies that we might think of. Julie had mentioned, getting, what is it, 48 Republicans to actually vote for the Equal Rights Amendment seems like a
not possible lift in this current Congress. You can't get 10 Republicans to agree that people should have the right to vote. Since Republicans now are working to appeal not only abortion, but they're also working to appeal birth control with this current Congress, that is not possible.
well,
I mean, you can have the conversation, but what we did in Virginia when we realized, and this is Virginia 2017, we were 1 seat short in terms of having control of the Virginia House. We realized that even being 1 seat short, we still can't accomplish what we need to do. So we, in the 2019 election, decided our strategy had to be change who is in the seats in the state house. Our strategy is going to have to be change who is in the seats in Congress. That is the real strategy we're going to have to employ. And we are going to need to change the Senate so that they get rid of the filibuster rule. Harry Reid could have gotten rid of the filibuster in 2009 when the Democrats had 62 senators. He chose not to, saying, well, there may be a time when we're in the minority and we might need it. Well, we're in the majority and we can't do anything. So that didn't exactly work the way I think he was anticipating. So again, we have got some antiquated rules that we really are going to have to change. Otherwise, we're just going to watch our rights keep being rolled back, because people are hanging on to something very outdated that allowed a minority of the senators to keep the majority from doing what needed to be done. So
I
yes.
see a question popping up.
Yay.
Do you have any thoughts on how getting the large amounts of money out of politics may or may not affect the ERA's passage, in particular overturning Citizens United?
Oh, that is a great question. And I went to a panel at the Women's Summit on that. The 2020 presidential race cost $16 billion. That is beyond insane and obscene. So yes, big money in politics really does impact the votes of a lot of people. And again, we're really talking about corporations who are saying, wait a minute, we have to pay women equal to what we pay men, well, that's just going to be really, really expensive. So we really do have a lot of corporations who, quote, as the job creators, really don't want to pay women the same amount of money they pay men. So, but again, you're going to run into a very similar problem. In order to pass a constitutional amendment to overturn Citizens United, number one, you're going to need to have 218 people in the House to say, yeah, that's a good idea. Move to amend has rarely gotten more than 52 people on their constitutional amendment. Back in 20, I think Jackie Spear took the bill maybe in 2017 was when Jackie Spear took the bill. It was after the Trump election. We had finally gotten to the point on the Equal Rights Amendment where we had 104 co-sponsors. And I remember when Rob Andrews left the House, and because it was a constitutional amendment, when we reintroduced, our sponsors were going to go down to 0. I asked Jackie Spear, do you need us to go and get the 104 co-sponsors back? And she said, I've got this. And she opened that bill with 110. Getting rid of Citizens United is exactly the same problem as ratifying the Equal Rights Amendment. The wrong butts are in the seats in the Senate. They just are. And then we've got some crazy butts that we need to get out of the seat in the House.
Well, my question then would be, where are the possibilities as far as Senate go in this upcoming election? Because if we're looking for advocacy in 2024 and beyond, we really have to be focusing on trying to get different senators elected if possible.
Right.
So where do you see there's hope? Or certainly the Democrats are in not a very good position in 2024.
Actually,
When it comes
they
to
are.
the Senate.
Well, when it comes to the Senate, they're actually in a perfectly reasonable position. Yes, there are some statewide seats that you're never going to be able to win, but there are other statewide seats that, with work and or possibly a change in the person that's running that seat, would be possible to get. In 2017, Virginia was down. Now, this is a state, but still, Virginia was down 15 seats in the Virginia House. In one election, we won back 14 seats, and we were one vote from winning the 15th seat. So it takes a lot of work in elections, and we are going to have to do some things that are different. One of the things that I do that is different, that allows us to win races that other people go, oh, you're never going to win that race, is number one, we look at who is voting in that area, who is not voting, and what would it take to get people who are not voting again. We used that strategy in 2017 in Alabama. We realized nobody was bothering to do outreach to Black voters in the Alabama Black Belt. So we did that outreach and we won that race. Now, when we won the race, the voters told us, if you expect us to come out and vote again, well, we've got some issues and we're not voting again until you fix those issues. Well, the issues that they had never got fixed. So the very next election, Alabama went, well, we know who they elected, Tommy Tuberville, and he's making quite a name for himself. So When I look at elections, I look at who lives in that state. Are they voting or not? If they're not voting, are they people of color and young people? And the answer always is yes. There are people of color and there are young people that are not voting. So then the question becomes, why are they not voting? Are they not voting because nobody's bothered to contact them? Generally, with people of color, that really does seem to be the case. So it may be there's just a whole new set of voters we need to talk to. And we've been very successful in most states. We have not been successful in North Carolina. And that's because people in North Carolina don't seem to want to work together. But when the folks in Georgia decided they were all going to work together because they wanted to change how stuff worked, they did. And they came together. And in 2020, the state of Georgia, which is south of Virginia, sent a Black man and a Jewish man to Congress as their US senators. So determination, analysis, and then go do the work. Oh, I have another question, or is that the same one? Is there any value in talking about the ERA now when top of our mind is fighting for our democracy? What are the top issues to focus on getting Dem supporters to the polls? I like your question. Dem supporters. Young people and people of color are no longer registering as Democrats. So that means when campaigns, political parties plan their outreach, they cannot keep calling the same people that they know are Democrats. They have got to drastically expand their universe so they have more people. And Dr. Suk was right. People have forgotten what the Equal Rights Amendment is. So unless you say Equal Rights Amendment, if you say ERA, they're going, why are we talking about earned run averages? You're going to have to explain it. And even when you talk about the Equal Rights Amendment, states that ratified years ago and have not recently gone through a ratification, they're going to be going, did we ratify the Equal Rights Amendment? We ratified. I heard we got 38 states. And now you've got a long, complicated explanation. For women, we have again tied the Equal Rights Amendment to bodily autonomy. So that is the topic that will get attention. Abortion is on the ballot this year in Virginia, and it will be on the ballot next year in the national elections. So that is the issue that women immediately understand. Now, the Phyllis Schlafly's of the world, who are upper middle class women who have the money to do whatever it is that they want to do. All right, we may not be able to talk them into joining our cause, but other normal women, and there are a lot more of us than there are of the Phyllis Schlafly ilk, they need to understand how these issues are tied together. How, if you have no rights to control your body as a woman, why do you think you're going to be able to maintain your ability to vote? Notice I didn't use the word right to vote because we don't have a right to vote in America. There are many of us who have an ability to vote, and there are many of us who don't. So I love that question. When we talk about issues, America is a somewhat, I didn't say very, I said somewhat complicated country. So our set of issues are not going to be the same for everybody everywhere. women having the right to control their bodies. What we do with our body is between myself and my doctor. That is something that all women are going to understand, and most are going to agree with you. When you look at other issues, we have these things that are called democracy centers, and we put them in communities where people no longer vote. They're normally low income Black communities. We'd love to get a Hispanic one going, but all the ones we have now are low income Black communities. And we don't tell them what their issues are. We go in and we talk to people and they tell us what hurts. So that when it's time for us to get out the vote, when we tell them or ask them to vote, we tell them why. Or if we are on our C4 side and we can say, we have endorsed this candidate because, and then they get their issues back. They will fight for reproductive rights, for trusting teachers, for protecting your voting rights. Whatever the community told us, we give it right back and we remind them voting is important. You're not voting for prom king and prom queen. You are voting so your community will get this, or at least get on the way to getting whatever it is that they want. We have those conversations every day.
Andrea, are there particular Senate races that we should be paying attention to?
I'm not even looking at the Senate right now. I'm focused solely on Virginia because Virginia has an election in 2023. All 140 seats in the Virginia General Assembly are up for election. When we did redistricting in 2020, the lines weren't properly drawn in 2021. So in 2023, we are having our very first election based on the new district. Now, in 2021, Virginia had a very unfortunate gubernatorial race. The Democratic candidate was the worst candidate in the history of candidates ever. And the Republican candidate won. And now this is going to be of concern to every person in this Zoom room. The Republican candidate's name is Glenn Youngkin. He is tall, he is handsome, he can stare straight at the camera, and he can lie to you. He pretended that he was a moderate Republican. What did he do when he got elected? Well, he is working to establish a 15-week abortion ban in Virginia. Virginia is the last Southern state that our ban on abortion, unless your doctor says it's medically necessary, is 26 weeks. All the other Southern states are 12 weeks or less. Virginia governors had instituted a plan of automatic voter restoration of rights for people with felony convictions in their past. You get out of prison, you have the ability now to register to vote and vote. Without saying a word, he changed the precedent of what has been the way things have worked in Virginia since 2016. He took us all the way back to the way things work in 1902. I'm the governor and I can restore rights to anybody I please or not. He also is changing the curriculum in Virginia schools so that, yeah, he decided he was going to leave certain portions of history about African Americans in the curriculum. He was just going to remove the why. Rosa Parks refused to give up her seat on the bus. Okay, and she's in the history books because she refused to give up her seat on the bus. So it's very, very interesting. If Glenn Youngkin, right now in Virginia, we have 40 Senate seats, 22 are Democrats. We have 100 House seats, 52 are Republican seats. They attempted to overturn every voting rights bill. Virginia has the equivalent of the John Lewis Voting Rights Advancement Act. We have the Virginia Voters Bill of Rights. That was Senator Jennifer McClellan's bill. He is working as hard as he can, but he doesn't have the votes in the Senate to literally get rid of early voting in Virginia, to get rid of our permanent vote by mail list. He realized that we win elections by getting our voters out to vote early. So now he has created a website urging Republicans to sign up for the permanent vote by mail list, sign up to early vote. Now, remember, President Trump told Republicans, we vote on election day. We don't do that early voting stuff. You know, it's fraud. It's rife with fraud. So it's very, very interesting. If Glenn Youngkin wins the General Assembly in Virginia, he will be the presidential nominee in 2024. And he will have a Ronald Reagan story. I took Blue Virginia in 2021. Before that race, we had a Democratic governor, lieutenant governor, attorney general, and both houses. If he wins the General Assembly, he will have taken Blue Virginia and turned it red. He is tall, he is good looking, he is 3/4 of a billionaire. He is Trump with a brain. He will be the nominee, and there is no Democrat I see on the horizon that can beat him. We must destroy him here in Virginia now.
And, you know,
Yes.
Andrea, we will do everything that we can in postcarding and activism that we can to help you make that happen.
Now, I don't have my Senate plan yet because I'm concentrating on Virginia. Would you like to peek in my brain and see my Virginia plan? Well, I have it right here.
Sure.
Okay, you're like, yeah, show me. All right, now, as I said, Virginia has 40 seats. There are 15 seats where a dead Democrat is going to win that seat over a live Republican 7 days out of the week. Any of the seats in green are seats where we're going to need to work to win this seat. So again, remember, a lot of people are running in seats where there's no incumbent. This is a brand new seat. It is anybody's seat. All right, so we've got this seat here. It's in Hampton Roads over on our ocean side. It's got 58,000 Black voters. 40.41% of the registered voters are Black. Generally, if I've got 20+% of registered voters of color in a district, I think I'm going to be able to win that district. Clint is a current delegate. This is a new district, so there's no incumbent. I think we can take that district. Here's We're going to skip over Jaleesa's district. We're going to go down to Aaron Rouse. Aaron Rouse just won a Senate seat on January 10th. That was the old district. He now has to run again in the new district. Again, it's 24% Black. These are registered voters. These are not just Black folks. These are registered voters. So I'm looking at this and going, I know there's at least 40% of these folks that don't show up and vote. Since Virginia has elections in off years, the Senate seat is going to be the top of the ticket. A lot of folks just don't show up and vote. These races are all about turnout, turnout, turnout. So we'll be working to turn out all the voters of color. Jennifer Carroll Foy ran for governor. She came in number 2 behind Terry McAuliffe, who then proceeded to stink up the race. She will probably take this Senate seat fairly early. So I'm going to have to pick a color between green and yellow because she's probably got this. I'm going to watch it. She doesn't have a lot of Black voters, but she's in Northern Virginia in a district that trends blue. Joel Griffith, this is a guy who's got an amazing story about why he's running for office. Again, it's a relatively small part of his district. We think voters are really going to like him. Now, what we're going to do with Jennifer Carroll Foy, if she seeks the endorsement of the National Women's Political Caucus, then we will go in and we will reach out to all the women in the district. And again, these are middle to upper middle class women who probably are not excited about the idea of having 6.5 children. They have 2.5 children, which is where they want to be. 6.5 is not where anybody is trying to go. So we've got more races where, yeah, the Democrats are going to get it and they're the incumbents. I met some of these candidates and they are really amazing. They don't have any money, but they've got amazing ground games. They're out knocking on 100 doors every night after work. So we're going to look at his race. We're going to show him some love. This woman, Trish White Boyd, came out of nowhere and won a 3-person race. She was one of the races where they're like, you're never going to win this race. Why are you wasting your time? Well, she won. And she's in a district that tends to go very Democratic. It leans Democratic. We think she can take it. Schuyler is in a tough district, but he's a great candidate. And there are 2 House candidates that share part of his district. They're working really hard and they happen to be women. So we're coming in and we're working with them. We
Andrea,
think Schuyler. Yes.
Could I, how about if, since we're kind of going off into another direction, I'll finish the ERA talk and then you can continue on. How about that? That would be wonderful. And then those people that would be great. So thank you for your inspirational talk. And I hope that we can continue on after I do some closing remarks. Keep around. Let's see. First of all, I'd like to thank both Andrea and Julie for giving amazing talks. And I'd also, in the Mobilize link that's going to come out, we're going to be sending information on postcarding and how you can get involved with postcarding and Livermore Indivisible. So keep tracking that. And we're just certainly going to be helping out in Virginia. And I also want to remind you about the Livermore Indivisible's next meeting on August 20th. We are excited to have Sheila Burks, who is the Manager of Equity and Inclusion at the Alameda County Community Food Bank, speak on race, power, and poverty. I really want to stress that it is an in-person meeting only, and it will not be recorded. So if you want to attend, please sign up. It will be held at the Livermore Library, but it's going to be in person only. So thank you for attending our talk on the Equal Rights Amendment. Have a lovely day. And if you want to stay around and hear about Andrea's strategy for Virginia, please do.
Oh, thank you, Julie. And I dropped a note in the chat. Every event that we do in Virginia, the Equal Rights Amendment and where it really is and what people can do right now will be a very integral part of what we do.
So if you want to continue talking about Virginia, that would be wonderful, Andrea, but I just wanted to.
I will make it really, really quick and not painstakingly go through each race. So you've seen the numbers and you understand how I'm thinking about this. So I will quickly finish up. That's the Senate. So 15 surefire seats. We're going to work on picking up 10. We really only need to win 3 seats. So if we win 25 seats, we control the Senate. There's only 40 seats in the Senate. In the House of Delegates, there's 100 seats. 33 we're sure of. There's 2 where we're pretty sure they're going to win. And then we've got 20 possible seats, and I may take that up to 24 based on the candidates that I met. I'm going to be talking to some of them later this week, where there may be some other races where just because of the candidates' work ethics, when the election is, and the population in the district, we should be able to win that race. Here's one of my favorite races, Josh Cole. Josh Cole lost his race in 2017 by 63 votes. In 2019, he won. In 2021, because the Democratic candidate had no coattails, he lost. So now we're going back in 2023. It's a slightly different district. We're going to try to get that seat back. So, yeah. So I just like people to see, and I told people the other night, this is all about our battle cry will be 25, 55, 25 Senate seats, 55 House seats, at which point then this should get Youngkin off the national stage, and we will probably be back to the typical Trump stooges, who will be easier to beat.
I think now we can, since we're off our normal webinar, if anyone is interested, they could chime in with questions, I believe.
Yes.
Can you hear me?
Yes.
Yeah, we can.
Hey, Lorene.
Hey, Andrea. I don't actually have a particular question. I just really want to thank you for your work. The stuff you do is amazing, and I'm just always floored at what you go after and what you accomplish. And so I just want to thank you for that.
Oh, thank you so very much. And again, it's the indivisibles all over the country, especially in California, who come in and support us in our work. You make the phone calls, send the postcards. This is really so incredible. And it's really unfortunate. The Democratic Party in Virginia is such a mess, but I have made it a point to build our own infrastructure in Virginia and Georgia, where we are not dependent on the party to do anything, because normally they don't do much of anything at all that's helpful.
Okay, I was gonna say, I appreciate your thoughts on Youngkin. You're right. He's he
He's
comes
scary.
across as reasonable and kind of nice guy, and the things he's doing, I agree. I don't think a lot of the ladies that voted for him, who I think were kind of upset about masks and vaccinations and
Yes.
stuff, I don't think they realized what they were getting. Hopefully they understand now.
Yeah, I think that a lot of folks would really like to get their votes back.
Good. I'm glad they realize that. That's necessary. Yeah.
Right, yeah. Renee. Oh, you muted yourself again. You unmuted and then muted. There you are.
Hello, hello.
Hey.
Any thoughts? I'm very, very concerned about the Republicans going after the Latino vote. I think that they see that there's even greater potential, greater inroads to be made there than with African American. So just like you're thinking about that, because
yes,
I'm
yes.
pretty scared, and and I mean, California is really important in terms of us winning back the House.
Yes.
We underperformed.
Yes. Yes.
Any thoughts about that?
And again, this comes down to when you neglect a whole segment of society and suddenly somebody pays attention to them and listens to their concern and appears to sympathize or empathize with them, then people will give that group attention, where normally they would just be like, oh yeah, right, you're the people who want to send all immigrants back where they came from. No, thank you. Goodbye. And that is really the problem. In most states, you can normally assume that between 90 and 93% of all African Americans are probably, the law of big numbers, going to vote for Democrats. In 2009, after President Obama got elected, Michael Steele was chair of the Republican Party. Michael Steele invested $10 million in Virginia recruiting African American ministers. Now, 15% of African Americans in Virginia are Republicans. So it's investment, who takes time to pay attention to people, and as I hear you, that's a valid point, but have you thought about it this way? In so many communities, if the Democratic Party exists at all, it exists predominantly to raise money. If you cannot be a donor, they have no interest in you, regardless of what color you are. Republicans figured out a long time ago, you may not have any money, but you got to vote, and we want to get that vote. And that's what we're seeing in Texas. That's what we saw in Florida. That's what we saw in Virginia. I've kind of, and in a lot of groups, we've stemmed the tide. We don't have people going over to the dark side, but we still haven't gotten that 15% of our folks back either. Yeah, I'm very concerned about that too, Renee. Yes.
Well, we got to put our thinking caps on.
Yes, yes, we do. Yes, we do. So again, that's why whenever we go into the community, we talk to the community first about their issues. We make sure the community feels heard, then we empower people in the community to go talk to other people, because we say, look, there's 8 of us right now. We're going to need an army of people if we want to change that. And then the people in the community, they go out and they work to build their army. And so if they're working to build their army to fix what they deem are their community ills, they're probably not going to be that easily wooed by the other side. Psst, come over here. I've got to go away. Thank you. Keep walking, keep walking. So, yeah.
Yeah, I mean, I can go on forever, but the fact that the GOP, does not honor separation of church and state. And so
Right.
for them, the ministry is, it's up for grabs. Whereas the Democrats, we recognize church and state, and a lot of the Latinos, they think God and country is perfect. That's what
Yes.
they want to be. So that's why, the Republican, song and dance and all
They
their
play
lines
on that.
makes
They
sense.
play to that.
Right. And
Yes.
how to counter that is something, I mean, I don't know. Just don't know. All right. Sorry.
No, it's not sorry. I just wanted to tell you, because that's exactly why Cecilia is already starting to talk to the voters in Central Valley. So we need more volunteers who goes in, and we use the voter registration, but it's just the reason to knock the door. And the reality is we need to talk to everybody. And if they are not registered, we register. But more importantly, we talk to them, and we have to show we care. And that's a lot of work, but we have to do it now, I think. And Linda said, what about the counties that have no one running in them?
Right.
That's a question.
Right. Well, okay, let me take a quick, you got to know what running in them. There are, that really is a problem. In Virginia, yes, you see a number of counties where there's no one running. Generally, those are counties where we wouldn't really have the resources to help someone if they decided to run. So we're going to be able to live with that this year. We have a lot of, if you're looking at my sheet, or when you saw my sheet, there were a lot of names where there was no color there at all, and there was a candidate. This is a first-time candidate with absolutely no money. And so we're looking at, do they have a clue as to what they should do as a candidate? Some of them don't. And the ones that don't, there's not really much of anything we can do, because our resources are very, very finite. But for candidates who are working a day job and then go hit 100 doors every night, okay, let's see, based on the population in your district, if we can work with that. So the notion of having a candidate in every district is a great concept if you have a party that will support a candidate in every district. I don't know what the Republican Party does now, but it used to be, if you became the Republican nominee for a state delegate, you automatically got $100,000. It didn't matter how bad a candidate you were. The Republican Party was going to give you $100,000. That is not true for the Democratic Party. If you run for a seat that the party has decided is unwinnable, they are going to fight you every step of the way. Wow.
That's just too bad.
Yeah, they're like, why are you wasting our money and our resources? And again, my mentor told me, and I agree, for every race where you don't have a candidate, you automatically lose.
Yep.
Is that you, Kyoko?
Yes.
I thought so. Hello.
Okay, if there is no other questions, we are gonna close this webinar. Thank you so much, everybody joining us.
Thank you,
Thank you.
Andrea.
Thank you,
you.
Christine, Lorene,
Thanks,
Linda,
everyone.
Helen, Susanna,
Thank you.
Sandra, Marilyn, Tom, everybody that I can see. It was wonderful, wonderful. Karen, getting a chance to spend time with you. Absolutely great. So,
you.
yeah.